it's great to welcome you back as we're continuing and indeed this time around concluding our short series this summer on the American Constitution, calling it The Roots of the American Constitution. Of course, we're doing a little more than that. We've been looking at some of the content of the Constitution and the amendments, and looking at some of the ways in which the Supreme Court has applied the content of the Constitution through the years to various issues that, of course, have come to its attention. I'm calling this last presentation Family Matters. You may have noticed that because I want to focus this time not so much on any particular provision in the Constitution, but rather how the Constitution has been used with respect to matters related to the family. And that, of course, once again represents a rather important issue to all people, of course, especially to those who are in the Christian tradition and who place a very high value on what's sometimes called the traditional family or the nuclear family. That idea of a husband and a wife and children, you know, the standard sort of traditional understanding of how a family should operate. Of course, once again, when we think about where that notion came from, we don't have to look too far. We know that biblical texts give us a very clear and distinct picture of the ideal family having that structure. Going back to Genesis, even before the fall had entered the picture, we hear that a man shall leave his father and mother and cleave to his wife, and the two of them will become one flesh. And of course, that statement is repeated not only in the Old Testament, but in the New multiple times. No one less than Jesus himself will invoke that very statement to give the proper definition of the ideal family. Manifestly, you know, the Bible sees variations from that. We have polygamy, we have that sort of thing going on. But when you ask what's the fundamental vision of the family in the Bible, it's not too hard to demonstrate, I think, to most reasonable people's satisfaction, that that is the basic architecture of the family. The family was a somewhat beleaguered institution, of course, through the Middle Ages and so on, but with the Protestant Reformation there was a very clear reinstatement of that particular view, especially with Luther and his famous marriage to Katie van Bora, of course, and John Calvin. Idelette de Muir was his wife, and the two of them and many, many others in the Reformed tradition gave a sort of a renewed expression of the importance of family, and that certainly was in the minds of the people who were framing the United States Constitution. And so what is interesting, of course, to those of us who follow these matters is how much the family has become a target of a somewhat, I would say, energized attack to try to either redefine it or renegotiate it or even remove it, you might say, from the normal institutions of human practice, and we who have a more, you might say, profound commitment to that traditional vision have viewed this with a certain degree of concern and at times even alarm as we think about what has been taking place. What I'd like to do at this point is not get on a soapbox. That's not really my purpose in any of these presentations. But I would like to give you at least one lawyer's assessment of where we are, how we got here, what the issues are that have been used in connection with the Constitution, and what thinking individuals might do, what might think, might want to undertake in terms of a response to these matters. So with that in mind, let's start with a word of prayer and then we'll get underway. Our Father, we're grateful to you that you've given us this opportunity to share together in matters connected to certainly American history and of great interest to many others. We pray that you would bless this time together, give clarity of expression and accuracy of content, and all of that in honor of Christ, in whose name we pray. Amen. All right, well, the first issue that I'd like to raise here, somewhat controversial one, I'm sure you're aware, is the whole matter of homosexual rights and how that is to be understood and how it has been understood in terms of constitutional history. I think you're well aware that certainly people who hold to that traditional view of marriage have felt increasingly embattled in this culture and many other places as well, but certainly America's been no exemption from that particular view. We're all aware in many states of attacks that have been brought to bear against people, sometimes professional people, because their Christian faith has run afoul of rising values in the culture that really begin to represent, at least to some degree, even a legal responsibility and exposure. I'm certainly aware in the state of Washington that we've had cases brought by the Attorney General that have effectively put people out of business because they refuse to embrace the contemporary views of matters related to the marriage and sexual behavior, that sort of thing. There was a case in New Mexico some years back that involved a photographer. He liked to take photographic journals of weddings and other events, and he was requested on one occasion by a gay couple to perform photographic services for them in connection with the marriage that they had coming up. Well, he declined politely based on the idea that he was a Christian and couldn't really endorse what was being proposed at this point, and felt that in good conscience he would have to decline the invitation. Well, as a result of that, he was sued. This was a bit of a setup, of course, but he was sued by this couple for discrimination, and the case, in fact, made it to the New Mexico Supreme Court. And the New Mexico Supreme Court was bound by statutory law in Mexico, which viewed homosexual orientation as a protected class. And as a result of that, the Supreme Court reached the conviction that the gay couple would win in this case, and that the photographer had in fact violated the law. I will say that that decision was not reached without a certain degree of heartburn on the part of the New Mexico Supreme Court. One of the justices, writing a concurring opinion, said that this photographer was now compelled by law to compromise the very religious beliefs that inspired their lives, the lives of this photographer and his family. And of course, at this point, though the concurring opinion supported the decision, this particular justice was noting what an impact that could have, certainly in the case of this one party and maybe many others. He said, quote, "Though the rule of law requires it, the result is sobering." And he added, quote, "It will no doubt leave a tangible mark on the Huguenots," the photographer, and others of similar views. This is certainly the kind of thing that we find happening, and it does raise concern, of course, on both sides of the issue, I suppose, but especially those who feel that they're being constantly and maybe persistently pushed into a more untenable corner. They find this a somewhat difficult thread to, or a needle to thread, you know, that idea. Well, the first time that the United States Supreme Court dealt with the issue of homosexuality was way back in 1968. This was a case that was known as Bowers versus Hardwick. So the Bowers case, this is the early case, 1968. This involved a statute that had been enacted in a certain state, which basically declared that sodomy was illegal. So that was the basic content of the statute. The nature of the statute, I think, is worth commenting on. This is sometimes called in the law an imprecatory statute. An imprecatory statute is a statute that no one really expects is going to be enforced. It's not really the reason it's on the books. It's not an authorization for people to go poking around in people's private affairs, you know, trying to find some kind of infraction of the law. It's almost impossible to enforce these, and very seldom would they be enforced. But the purpose of an imprecatory statute was essentially for the social order to make a declaration with respect to a particular moral issue. To, in other words, say, kind of officially, we view this particular practice as illegitimate or immoral. So the statute has that particular function. And imprecatory statutes have been quite common, not only in American history, but many other places. And that was the kind of statute that was in view here. Nevertheless, a case was brought challenging the constitutional authority of such a statute, and that case did in fact finally wind up before the United States Supreme Court, which ruled in a close call, 5-4, to uphold the statute. So in 1968, the Bowers case upholds a statute which is essentially imprecatory in character, that declares that the people of that state had the right to make a declaration concerning what was viewed commonly by the ruling majority in that state as an immoral behavior. The case, Bauer's case, really covered a great deal of constitutional history. It went all the way back to 1791 and the views at that time connected with the year that the Constitution was ratified. It traced it through to 1868 when the 14th Amendment was ratified, and of course all through constitutional history it came to the conclusion, of course, that it was acting in a way that was consistent with general public views all through those years. Now at this point, the Bauer's case was simply declaring that on the basis of the history of the treatment of this subject in American culture, any change of the morality should not properly come from the court. The Bauer's court was saying that if there's going to be a change, that should be as a result of some kind of robust political debate. The court shouldn't simply weigh in, substituting its conscience for the conscience of the nation, that there should be an opportunity for people to debate both sides of this issue in election campaigns and in legislative chambers, that's the place where it ought to happen, and ultimately the decision should rest with the voters of that particular state. That was the view that was taken in Bauer's. And so really what was happening in Bauer's was simply the court was saying, we don't think it's our role to begin imposing our morality on states. We should leave it to the people. That's really the nature of a constitutional republic. Warren Burger, Justice of the Supreme Court at the time, wrote, quote, "To hold that the act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside millennia of moral teaching." And of course, he's simply observing the obvious at that point, that for the court to sort of enter into that conversation on that basis would be a somewhat risky thing to do. Well, that was the decision of the court. It was probably the right decision, but nevertheless, you can imagine the backlash from that point on in the press was unrelenting and in some cases vitriolic, as all kinds of attacks were brought to bear in connection with the decision in which the Supreme Court was unwilling to impose its own conscience on matters related to this particular issue. This challenge has been generally pursued through the years based on an idea of anti-discrimination. This applies in many different quarters, of course, in our culture. There are restrictions on attempts to discriminate based on various classifications. I can just take one example to illustrate the point. That generally speaking, in America, employers, someone starts a small business, they are free to hire who they want, and as a general rule, to fire who they want. They don't have to answer to some kind of legal tribunal at that point. It's a country in which a person's freedom to start a business and so on is pretty much left to the discretion of the individual doing so. Now, there are exceptions to that. So the freedom to hire and fire can be restricted by statute and often has been. If we go back to the 1960s and the enactment of the Civil Rights Act, we know that thereafter, discrimination in hiring or firing based on race or religion or gender became illegal in a statutory way. And so from that point on, if a person was going to dismiss someone, then they had to make sure that they were doing so in a way that was not simply predicated on some sort of discriminatory action related to those protected classes. Those are protected classes. Not every class is protected. There's no protected class for people that are ugly as opposed to beautiful, tall as opposed to short, athletic as opposed to non-athletic. There's all kinds of classes out there, but some of them are protected. And it's the protected classes that become the subject of these kinds of statutory restrictions. The decision that was made there in the early 60s and on that basis was based on the 14th Amendment, the First Amendment, the 19th Amendments, and so it was on pretty stable ground based on at least the history of the constitutional treatment of it, and of course based on the prevailing sentiments at the time. I think you're aware that we have, however, had over the years, indeed over the decades, a somewhat changing moral climate. And so there's an increasing pressure that's put on people who have traditionally seen homosexual behavior either as destructive or at least as violative of biblical norms. And that pressure, of course, is pretty conspicuous, and I don't think you have to be paying that much attention in our culture to know that it's been going on, and going on with a fair amount of energy. Over the years, we found various responses to this kind of phenomenon. The Boy Scouts, at a certain point in their history, of course, had a rule that would restrict scoutmasters from being homosexuals. When they announced that publicly a few years ago, the Disney Corporation defunded them right on the spot. Virginia actually passed a law requiring agencies to include homosexual couples in their adoption considerations. That sort of thing has gone on, and we've seen it going on with increasing frequency over the years. It's become a rising issue. I'm not telling you anything you don't know. The next case really in the Supreme Court's history that dealt with this issue was known as Romer versus Evans. This was a 1996 case, and I think it's safe to say this was the first time in constitutional history that the homosexual movement really could claim a significant victory. This was a case that came out of a state that had an initiative. That is to say, it was something that originated with the people, an initiative measure, which was going to remove the phrase sexual orientation from the list of protected classes. So in this state, we had protection as to race, of course, gender, and so on. One of the protected classes that was included in that list was sexual orientation. And the people of the state, on their own initiative, rallied enough of a movement and got sufficient signatures to put it on the ballot. And the people in that state actually reached the decision that they wanted that particular protected class to be removed. In that case, the U.S. Supreme Court concluded that even though that was an initiative procedure that came out of the popular will of the people, it was unconstitutional. And so that was the first time that the court actually, in a sense, overruled what you might say the popular will of the people. It was kind of an effective overruling of Bowers, but didn't quite do so expressly. The express overruling of Bowers came a few years later in the most important recent case dealing with this subject, which is known as Lawrence versus Texas. Lawrence versus Texas expressly overruled Bowers and a statute, an imprecatory statute, that had banned homosexual acts. The court reached its conclusion based on a minimum scrutiny test. Now, I've told you about scrutiny. You know, we have strict scrutiny and we have minimum scrutiny. Strict scrutiny, the state has to show at a pretty compelling level that it has an interest in establishing the particular kind of distinctions that it wants to enforce. And minimum scrutiny, basically what the state wants to do is going to be permitted unless it's utterly arbitrary. Well, interestingly, in the Lawrence case, 2003, the court elected to use the minimum scrutiny test, which of course almost assured the outcome would be in favor of those who were challenging this imprecatory statute there in Texas. Texas argued that a rational connection existed between this imprecatory law and the preservation of morality. The Texas Attorney General was not arguing that the law enforcement agencies were intending to go out and try to invade every home and look for people doing illegal things in the privacy of their bedroom. That was never the purpose of it. But the Attorney General was arguing that there was a good reason for the people of the state to be able to publicly announce what their views were of a particular practice. In the Lawrence case, the Supreme Court made a very interesting observation. I want you to listen to this language rather carefully. The court said, quote, "The fact that the governing majority in a state has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice." Now, you have to think that's a remarkable statement. The fact that a governing majority, that is the bulk of the people in a particular state, want to make a public statement in a statutory way that a particular practice is immoral is not sufficient reason for upholding that law. This is, of course, the place where moral issues are supposed to be decided. It is in the political debate. It's in people running for elective office. It's in debates that take place in the legislature. This is the whole point. Moral issues, of course, are constantly the issue under discussion in all kinds of legislative acts. Somebody said once you can't legislate morality. Well, if you didn't legislate morality, you wind up legislating things like the state bird, and that's about it, you know. If you drive your car 100 miles an hour through a school zone, that's a moral issue. It's possible to legislate morality. But at this point, the court was saying that even though the governing majority had reached a conviction that a particular practice was immoral, now the Supreme Court felt it had the duty to overrule that and, in effect, to substitute its own morality for the morality of the state of Texas. So the risk that we talked about some time back, you may remember this in connection with Brown versus Board of Education, a case that I like. I endorse the outcome there. But my caution was that the Supreme Court in Brown had basically reached its decision based on a moral assessment. And I happen to agree with the moral assessment, you know, and so you might think no harm, no foul. But what happens, this is the question, when the Supreme Court inserts its conscience in a way that is in fact inconsistent with, as the court says here, the governing majority, making its own conscience overrule the conscience of the people of a given state. Well, that's a risk that was created in Brown versus Board of Education. Maybe the most dramatic expression of it is what we find here in the case of Lawrence versus Texas. In effect, what happened was the court imposed its majority view of moral values on the state and thereby on the entire nation. It made the Supreme Court, as it were, the conscience of the nation. Again, for what it's worth, I think I said this before, but I just want to remind you of it, that these are imprecatory laws. They are rarely enforced. Attempts to enforce them are virtually non-existent. You think about the Fourth Amendment protection against unreasonable searches and seizures all by itself is pretty much going to make it impossible to investigate and gather evidence that would violate an imprecatory law. The purpose of the law is simply to allow the society to make a statement, and in some ways the ability of the society to do so, at least on certain topics, is now being significantly restricted by a decision like Lawrence versus Texas. So here the court found that the society could no longer censure homosexual behavior, and as you're probably well aware, since that time, of course, the growth and expansion of arguments for an ever-widening understanding of a protected class of homosexual orientation has been the order of the day in our nation. So same-sex marriage took place, was really enacted, laws in that connection not long afterwards. And I don't need to tell you the rest. My purpose is simply to give you an idea of the history of this, how it happened, and what the role of the Supreme Court was in the process. So that first point really treats the matter of marriage itself. What is marriage? What's a legitimate sexual relationship, at least that's going to be recognized by the state? That's been changing somewhat dramatically. And those who are interested in what you might call a traditional view of the family and of marriage should view this with some degree of concern, certainly as we're thinking about who we elect into public office and what their values might be. Another area where this matter has certainly come up with a fair amount of drama is the whole matter of parental rights. Once again, if you're paying attention, you know that there's been a fairly significant assault on the sanctity of the parental duty and responsibility with respect to children. The original view that parents had an immense amount of responsibility and duty with respect to their children was taken for granted. It goes back again to biblical values, certainly reinforced in the Reformation and taken for granted, I would say, at the time of the founding of this nation. But there has been in recent years a fairly significant differing vision of the role of parents. there's been an increasing interest in taking a more collectivist approach so that children don't simply belong to the family, in fact, maybe less to the family than to the broader society. There's been especially an interest to use public schools as a vehicle by which to more or less introduce a quasi-parental relationship between the state and the children, more or less freezing out parental involvement along those lines. One illustration of this that sort of highlights the point, I would say, it goes back to the year 2013. The cable news channel MSNBC did a story on what was called the Lean Forward campaign. The Lean Forward campaign was an attempt by certain sociologists, scholars, to try to really rethink the whole role of the parent in our society, and once again to call for more significant funding of public education to allow for this kind of quasi-parental role to be carried out with more effect. In that connection, there was an interview with one particular scholar, Professor Melissa Harris Perry, and she made an interesting statement. Now, this is a verbatim quote of what she said in answer to a question in connection with the role of public education. And her statement was, quote, "We have never invested as much in public education as we should have because we've always had a kind of private notion of children. Your kids are yours and totally your responsibility. We haven't had a very collective notion of, quote, these are our children. So part of it is we have to break through our kind of private idea that kids belong to their parents or kids belong to their families and recognize that kids belong to the whole community. It's once it's everybody's responsibility and not just the households, then we start making better investments, namely more sizable investments in public education to permit this very kind of role to be played by public educators instead of the family. And I think you're aware that we've had a fair number in recent years of cases where the public education system is teaching children things without the knowledge or consent of the parents and really keeping the parents out of the loop as much as possible. Well, a statement like that back in the year 2013, of course, represented a pretty good marker of the vision, the philosophy that would take a more statist approach to the way in which children are reared. The statement itself, while it was given extemporaneously in an interview, was nevertheless, I think you noted, a well-scripted, well-rehearsed response. It was promoting a certain view of parental roles in our culture. And I think any sober person listening it should have had a certain degree of alarm bells, going off in their minds as they heard a statement like that being made. Maybe the most important recent case that treats this is a case known as Troxel versus Granville. Troxel versus Granville. This is a year 2000 case. And it really gives us an interesting piece of evidence that the role of parental rights is at least being renegotiated, if not being shifted in constitutional theory. The facts of the Troxel case are fairly straightforward. There's a state. The state had a statute, and the statute permitted third parties to a family. These didn't have to be family members. They could be anybody, but any third party had the right to petition the court for visitation rights with a child. So that was the basic content of the statute. Well, in the Troxel case, some grandparents had petitioned the court for the right to visit their grandchild, even though the mother objected to this visitation. The reasons for it I won't bother you with, but you get the basic principle. Here's an outside family, the grandparents in this case, who want the legal right to have visitation with a child against the mother's objection. Well, what's the court going to do with that? The court actually struck down the statute, which in my opinion was the right thing to do. The court basically said that for a third party to be able to petition to have visitation with a child would really be an intrusion into parental rights, and as a result of that, that statute should not be allowed to stand. Now, so far so good, Justice Scalia, however, dissented. It may surprise you to hear that, but he dissented from that ruling. he would have ruled in the opposite direction. Now, that may surprise you because, of course, Scalia is well known as one who is committed to a rather strict construing of the Constitution. He wants to stick very close to its actual original intent, and for that reason, many people applaud his views. But sometimes that particular commitment can, cut both ways, and that's exactly what happened in this case. So Scalia, in his dissent to this opinion, made the following statement. Now, it begins in a way that I think, presumably you wouldn't disagree with, but is basically in these words. He says, "In my view," and by the way, I might mention that little phrase, "in my view," is quite strategic to the whole paragraph here. "In my view," he says, "a right of parents to direct the upbringing of their children is among the unalienable rights with which the Declaration of Independence proclaims all men are endowed by their Creator." All right, so in his view, it is an inalienable right. He continued, "In my view, that right is also among the other rights retained by the people, which the Ninth Amendment says the Constitution's enumeration of rights, quote, shall not be construed to deny or disparage." Well, so far so good. What Scalia is saying here wouldn't raise many hackles with people who were committed to a strict viewing of the Constitution. But then what he says in following that statement is where we might find an interesting dilemma. He says, quote, "The Declaration of Independence, however, is not a legal prescription conferring powers upon the courts, and the Constitution's refusal to, quote, deny or disparage other rights is far removed from affirming any one of them, and even further removed from authorizing judges to identify what they might be and to enforce the judge's list against a law duly enacted by the people." Now, I just want you to think about that. I was mentioning a moment ago about the Supreme Court inserting its conscience in place of the governing majority of a given state, and being somewhat critical of it. And I have to tell you, this is precisely what Scalia is trying to avoid doing. At this point, he's saying that if he were to find those robust parental rights as an unalienable right there that was sort of reserved to the people, he would be once again doing the very thing that we were talking about, inserting his own conscience, you might say, into the situation. It's kind of a tricky issue, isn't it? You have to see where he's going from. I have to admire Scalia's integrity at sticking so close to the Constitution, while I have some concern about the conclusion it forces him to reach. Scalia says, "Consequently, while I would think it entirely compatible with the commitment to representative democracy set forth in the founding documents to argue in legislative chambers and electoral campaigns and so on, that the state has no power to interfere with parents' authority over rearing their children, I do not believe that the power which the Constitution confers upon me as a judge entitles me to deny legal effect to the laws that, in my view, infringe upon what is, in my view, that enumerated right." In other words, Scalia is saying that this is a question which should be settled in the political sphere, and Scalia sees the court as something other than a political body. The Supreme Court has the task of, in an objective and detached manner, applying the Constitution and its objective content to the facts of the case. And Scalia would say that if he doesn't find in the Constitution some justification for reaching a decision, then it should go back to the people of the state. Now, I admire that. I think that's correct. I'm not sure I agree that parental rights don't really fall within the content of the Constitution, but nevertheless, at least you see where he's going here. The reason I say that is because there were earlier cases that also dealt with the matter of parental rights. Scalia, by the way, addresses both of these. He mentions both of them. He's very much aware of them. One of them was a 1923 case entitled Meyer versus Nebraska. This was an interesting case. It was a law in Nebraska that prohibited teaching in a foreign language in any school when the children were younger than 9th grade level. So you have a law supported, by the way, by the parents that would prohibit teaching in a foreign language in any school before the 9th grade. But there was a certain community in which the parents wanted to make an exception, you see. These were German people of German extraction, American citizens who were here. But they wanted to teach or have someone teach Bible stories in German to children that were younger than the 9th grade. And so there was a teacher who was doing just that with parental knowledge and with parental consent. But it was a violation of that statute. And so the teacher was actually prosecuted for teaching Bible stories in German before the 9th grade. Well, this is a similar issue. Who wins in this? Does the state statute win over parental rights, or do parental rights win over the state statute? You can see the conflict. The court analyzed the facts of the case in terms of liberty. Now, that's important, because even though we don't have parental rights named specifically in the Constitution, we do have liberty mentioned. A man cannot be deprived of life, liberty, or property without due process of law. Well, the question is, how broad is the term liberty? You see, how far does it reach? The court said in the case of Meyer, quote, "Without doubt it," and the "it" there is liberty, without doubt liberty denotes not merely freedom from bodily restraint. You see, now liberty at the very least would say that you cannot be incarcerated without due process of law. But the court here was saying, you know, the word liberty reaches a lot further than that. And so not simply freedom from bodily restraint, but also the right of the individual to what? To contract, to engage in any of the common occupations of life, to choose your career, in other words, to acquire useful knowledge, to educate yourself, you know, so on, to marry, to establish a home and bring up children. This court said that liberty covers all of those issues and more. To worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So the court's saying, okay, granted, you know, we don't have parental rights mentioned as such, as an inalienable right, but we do have liberty. And liberty is a very broad word, and it really is at the heart of a free society, and it should certainly include the liberty of parents, people to establish a home and bring up their kids accordingly. The court in Meyer was certainly aware that there have been other visions down through history. The most famous, probably, alternative is Plato's Republic that goes back to the 5th century BC in Greece. And actually the court in Meyer considered Plato's alternative. He had a very collectivist view, you know, of rearing children. He really would be an early endorser of the idea that it takes a village. That would be the notion you'd find in Plato. And the court in Meyer said, although such measures have been deliberately approved by men of great genius, you know, Plato, their ideas touching the relation between individual and state were wholly different from those upon which our institutions rest. Those would be Judeo-Christian traditions rooted in the Bible. And it hardly will be affirmed that any legislature could impose such restrictions upon a people without doing violence both to the letter and the spirit of the Constitution. And so even though this court in Meyer was aware that there might be options out there in terms of parental rights, we were founded in a tradition that held those rights to be in very high view. Scalia looked at that case, was unmoved by it, you see. He said, well, I think you're going too far. You say that parental rights are part of the Liberty Clause. I'm not so sure. And he would have ruled differently in the Meyer case. That's what he tells us in his opinion here. 3 years later, there was even a more important parental rights case. It was called Pierce versus Society of Sisters. This involved the state of Oregon, which had a ballot initiative which banned all private schools under the college level. It might be surprising to hear that, but there in Oregon, there was a initiative, once again, a majority of the people signed off on it, basically saying that there will be no private schools, religious or not, didn't matter. All private schools are going to be banned, and everybody in their educational process will be in public education until they reach the age of college. You might think, why in the world would a state pass a law like that? But it was really driven at the time in 1926 by some very strong anti-Catholic attitudes, strong suspicion of the Catholic Church at the time, and that's what really was the engine behind that particular initiative. So the argument in favor of that statute was that all children should be taught a common set of American values. Well, in the case of Pierce versus Society of Sisters, the court once again took a look at this matter of parental rights and made an interesting observation, once again returning to the theme of liberty in connection with its ruling, and saying, quote, "The fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." Once again, on that basis, the Oregon law, which was attempting to wipe out private schools, was declared to be unconstitutional. And once again, Justice Scalia, as he reviewed that case, reached the conclusion it was wrongly decided, because once again, it represented a situation in which an unenumerated right was being invoked here, namely parental rights, and he didn't find that sufficiently expressed in the Constitution to find in favor of that particular lawsuit. So it was a case of rejecting unenumerated rights. That was what Scalia's view was. I mentioned this to you not so much to try to be critical of Scalia. I like him, and I think for the most part his opinions are good. It really speaks to his integrity that though he says quite clearly that in his view he would like parental rights to be an enumerated right, nevertheless he grants that he just doesn't quite find it there. What's the end run? Well, he would suggest it needs to be resolved in the political process. It needs to be part of the public debate that takes place, and the people finally make a decision. It may be a decision that's expressed through the legislature or through popular initiative, but one way or another the people have to weigh in and become the governing majority. The other solution, which would be even more effective, would be to create a constitutional amendment which basically expressly included parental rights as an enumerated right that is reserved to the people. I don't really expect that to happen anytime soon, but my point is that from Scalia's point of view, that's the place where this debate needs to take place, rather than having the Supreme Court simply impose a view, once again from his point of view, imposing a morality, you might say, that is not necessarily justified by the document. All right, well, the last area that I'd like to deal with, that once again touches rather deeply the question of the family, is international law. Now, that may strike you as a little odd. You don't normally think immediately of international law having much to do with the family. But as a matter of fact, at least at this particular juncture in international history, we are at a point where there is a quite serious threat to self-governance in the United States based on the application of international law. And it's very good for us to be aware of this. And as we're questioning those people who are running for public office, to put these questions rather directly to them as to what exactly is their view of some of these things. Just by way of illustration, the land of Scotland, which by the way I love, the nation in which the Presbyterian Church was founded, of course, and we've talked a lot about Scottish history in our prior series there, but Scotland, at least at this point, will assign a social worker to monitor every Scottish child from birth. Now that's what happens in Scotland. It's statutory in Scotland. So if you're living in Scotland and a child is born, then immediately there's a social worker, a state employee, who is assigned to that child to monitor this child's growth and so on. The social worker, by statute, will be involved in advising, informing, or supporting the child. The social worker will help the child to access services or support that may be available through the state. The social worker will be involved in discussing or raising matters concerning the child with other state agencies. Now, I just want to say, if the Scottish people decided to put such a statute in place, okay, fine. I mean, the governing majority of a given population should be able generally to do what they want to do, and that would be simply the notion of self-government. At this point, however, the bill makes a very interesting statement as to its purpose for this statute, and it specifically states that the purpose of the statute was to move Scotland closer to compliance with the United Nations Convention on the Rights of the Child. So you see, the statute was not something that was sort of imposed out of the minds and hearts of the Scottish people, but it was in fact brought to bear by the legislature in Scotland in order to move Scotland closer to a United Nations Convention. A United Nations Convention that had very little to do with international relations, but a great deal to do with internal and domestic relationships. And that's really where we're seeing this issue then rise. So far, at this point, 193 nations around the world have ratified the Convention on the Rights of the Child. The United States, at this point, stands alone among member nations in refusing to do so. And the reason for that is because the United States, maybe more than any other country in the world, still has a very strong idea of self-government. And for that reason, it has maintained its stalwart refusal. Now, I don't know how stalwart that refusal is, and it's the reason that I think this should be of some concern, is because if the United States were to embrace and endorse the Convention on the Rights of a Child, it would have sweeping effects in terms of the internal life in this nation, especially family life and so on. Issues that have virtually nothing to do with international relationships, but everything to do with how we live our lives privately within this nation. Many have criticized the United States for refusing to embrace the Convention on the Rights of the Child. Others, of course, celebrate it, and they do so because the principle of self-governance was at the heart of the American Revolution in the first place. The very reason there is an America is because of the principle of self-government. The idea is that the laws by which we live should originate ultimately in the people. The Constitution starts with the words, "We the people." We do this. The United States framers understood that there were unalienable rights, a natural law of God, and that self-government was really at the heart of those basic human rights. And in fact, for 150 years, colonial America had lived based on that rule of self-government. It was only when Parliament unilaterally and without any representation by the people at all began to impose laws, taxation without representation, if you use that popular phrase. It was only then that the issue really was triggered in a way that led ultimately to the revolutionary conflict. Well, in a sense, we have the same thing going on here. If an international treaty can sort of weigh into your life personally and privately and tell you how to raise your children, for example, then you can see that that would represent, once again, a kind of intrusion which would really fall way outside the bounds of any notion of self-governance. There are certainly voices, especially on the left politically, who have argued relentlessly that this whole notion of self-governance should be abandoned, and that the United States should join the family of nations in the world. You hear that kind of rhetoric. So Americans are being urged to embrace the Convention on the Rights of the Child and other treaties, the Convention for the Elimination of All Forms of Discrimination against Women, the International Covenant on Economic, Social, and Cultural Rights. And I just want to make it clear that this is no argument with respect to the fact that there should be rules, against child abuse, that sort of thing. There certainly should be rules that apply to anti-discrimination policies as to women and others. That's not the point of this conversation. But the point is that those rules should be those which are enacted at the will of the people and not imposed by some kind of distant third party in which we have had no reasonable participation whatsoever. So really the question here is not so much the content of these for the most part, but it really is more an argument as to where is the authority originating that imposes those kinds of sanctions on life in this nation. I might mention, though, that some of these international treaties do reach much further than simply the stated purpose as found in the title. For example, the treaty that has to do with women includes much, much broader provisions that really go well beyond simply how women are to be viewed in a given society. For example, it provides for a new economic order of equity and justice that would promote gender equality. Well, the economic order is very different from simply that which promotes gender equality. It has much more far-reaching implications than simply a matter of gender equality. It incorporates a change of gender roles that would bring full equality between men and women. And some of those changes of roles would be rather dramatic if I were to read them to you. It also, rather strikingly, involves for the strengthening of international cooperation and actually calls for disarmament. All of those, of course, going well beyond the stated title of that particular treaty, and others like it really reach well beyond what appears to be the stated purpose of the treaty. So this is a treaty that would change roles for men and women. It would also disarm states and certainly disarm individuals, and all of that under the auspices of making sure we don't discriminate against women. You see, that's the problem we're dealing with here. You might think, well, you know, even if we were to embrace such a treaty, how could they enforce it? Alleged crimes against a treaty are tried in international tribunals. The Hague, for example, would be a commonplace, and international courts, even though the international laws are supposedly going to overrule the nation's own laws, nevertheless enforcement becomes very practically impossible, especially against a permanent member of the United Nations Security Council, which is what the United States is. But there is an end run here that is quite important. So advocates of such policies would seek to enforce these rules not in international tribunals, but in the domestic courts of the state itself. Because you see, treaties may not be enforceable domestically, but they would be if the state itself authorizes it. And in case you hadn't noticed this, let me just mention to you that the United States Constitution specifically authorizes treaties to be enforceable in the courts of this nation. So it reads, quote, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or law of any state to the contrary, notwithstanding." And so you do have a situation where in domestic courts in the United States you could see international law on a precise collision course with local law, and the outcome, of course, under the Constitution would have to favor international laws. Treaties were generally, traditionally viewed as having a particular purpose, namely to describe how nations should treat each other. Normally, treaties would deal with things like commercial connections, international commerce, that sort of idea. But when a treaty begins to reach into the inner life of a nation and dictate particular laws and behaviors and so on that have virtually nothing to do with international relations, then you know the treaties have basically taken on a somewhat different quality. So we have treaties now that incorporate issues of children, women, seeking to govern domestic life. The Treaty on the Convention for the Rights of a Child include, among other provisions, the child's education, discipline, health care, religion, food, clothing, housing, sweeping provisions, of course. And once again, while it's legitimate for a nation under self-governance to have rules concerning any of those matters, to say that it's going to be dictated by an international body becomes a somewhat problematic idea. So this is regulation not only of the state, but even of the parents. And of course, as I mentioned earlier, if it were ratified, such treaties would become the supreme law of the land. Well, we haven't embraced any of these treaties to date. There are certainly voices vigorously calling us to do so, and that's why we should be vigilant as we talk to our elected representatives to make sure that they understand the issues and that they will represent what is really a classical principle of American governance, namely that law should originate with the people of this nation rather than with external authorities. There is one end run that's been suggested by some, which is maybe even a little more disturbing. It's called customary international law. Courts, including the U.S. Supreme Court, have sometimes applied treaty provisions, not because we've embraced them, but under the auspices of customary international law. Now, sometimes customary international law simply goes to what are commonly called crimes against humanity, genocide, for example, something like that. But it can be applied at a more subtle level. So even if a treaty was not existent on women or children, the rule might be applied by a court based on the fact that the vast majority of nations should be following the rule and should do so not because it's been officially embraced, but simply out of a sense of legal obligation. And if that were the case, the U.S. might find itself bound to enforce certain treaty provisions even if they had not been ratified. And so you look at some of these treaties and see how many nations have already endorsed them, and it does give us pause. You know, for example, the Treaty on the Rights of a Child has 93 nations that have signed off on that. The Covenant on Economic, Social, and Cultural Rights, which is fundamentally a socialist document. If you read it, it's not too difficult to find that. 160 parties. The Convention on Women has 186 signers. All of these, of course, have been widely endorsed by other nations of the world. And it is the fact that sometimes courts in the United States, including the Supreme Court, have alluded to these international treaties, not because they're legally bound to do so, but under this notion of customary international law. Well, again, the reason for this conversation is just to sensitize you that the family is somewhat embattled these days, and it's on multiple fronts, and we who have some interest in the traditional view of the family, of course, should be wide awake to this and certainly be vigilant in discharging our duties as American citizens to protect what we believe is not only an American philosophical institution, but really has its roots going clear back to biblical sources as well. Well, with that, we're bringing to a conclusion this series. As I've told you before, the point wasn't to cover in detail the entire Constitution. We'd have to take a lot more time to do that, but I wanted to hit some of the high points, give you a sense of it, and hopefully all of this makes us a little bit better educated as we try to be about the business of serving our country well, serving as intelligent, informed citizens well, voting intelligently, asking good questions to our representatives. In other words, carrying out the duties that befall us as those who hopefully can contribute meaningfully and thoughtfully to our life. And so I'm going to leave it here. If you're watching these videos in real time, then I will just tell you that I'm taking about 6 weeks off now. We'll be not uploading anything to speak of over the next few weeks. The next series we're going to start will begin about mid-September, and that's going to be a series on the Gospel of John. We'll be taking a fairly close look at the text of that gospel over about a 2-year period of time as I envision it right now. So I hope that if you're interested in that topic, you'll be able to find your way back at that point. So until then, I wish you a very happy rest of your summer, and thank you for joining in, and we'll look forward to seeing you sometime in the future.